I'm Laura Terhune. Welcome to our final business breakfast of the year. 2020 has been quite the interesting situation for all of us. I did want to let you know that we are booking the conference center so that our business breakfasts can start to go back to in-person in January. Now we are going to watch situation with numbers. And if we feel like that is not the way forward, we will let you all know. But our members are telling us that they're ready to take precautions, wear their mask, and try to get things back to normal, especially now that the vaccine is going to be starting getting distributed. Let's all pray that it goes quickly and that we put this strange year behind us. I do want to let you know that at the end of this presentation, we've got a special announcement that is going to be made by our friend Sharon Price, CPA. Dr. Price will make an announcement right after Jacob finishes with his portion. Not rushing Jacob at all, but I don't want you, if you hear Jacob wrapping up, don't log off, because we think you're going to want to hear what we're going to announce at the end of this. So let's go ahead and get started, everybody. Let me start with an introduction of our speaker. Jacob Wallace is an attorney in Midlothian, focusing his practice on helping individuals and small businesses understand and resolve legal disputes. He also teaches government for TCC. Jacob serves on the board of directors for the Midlothian Economic Development Dispute Resolution Services of North Texas, and is on the Higher Education Center Advisory Board. Man, that's a mouthful. Sorry about that. I'm pleased to introduce our speaker, Jacob Wallace. Jacob, take it away.
Thank you, and I'll try to keep on moving. I've developed a reputation for talking a bit too long, so I'll try to keep that going. So let's see, I gotta share my screen, right? There we go. And then make it big. Everybody got this now?
We see it.
We're good. Okay, so I wanted to make a presentation. When the chamber asked me to talk about something, what I wanted to talk about was something comes up pretty often, and something I enjoy talking about. This happens a lot to small businesses, which is you have a legal dispute that comes up that's important enough that you don't want to walk away from it, but not really important enough that you want to pay a lawyer a couple of $1,000s to handle it for you. So you ask the question, can I handle this myself? And so really that's the focus of this presentation, is trying to figure out what kind of cases can you handle it yourself? And if you can and decide to handle it yourself, how to do that, what to expect. We're particularly looking at justice court in this situation, what to expect from that process, and some tips to make sure you get the most out of it if you head into that situation. The chamber came up with this wonderful title. Mine was something like "How Not to Pay Me Money," but they came up with this very clever "Carry a Big Stick Without a Big Bill." Of course, I'm a lawyer, so I have to start by disclaiming this entire presentation. Don't pay attention to anything I say. None of it's legal advice. This doesn't create an attorney-client privilege. This is just a starting out point. This is especially important in litigation. A lot of what we are going to talk about, really, it will turn on a word on clause 17 of your contract. And so this is a good starting point. But if you decide to represent yourself in a lawsuit, it's a lot of work, and you have to be ready to take that on. That's me. So let's jump right into it. So first off, what we're talking about is we're talking about disputes. And if you run a small business, you are used to getting into disputes with your customers, with your clients. It happens all the time. There's a lot of different disputes that come up. There's personality disputes. There's service disputes. There's, they're mad because you closed 15 minutes early on one day. Most of that stuff doesn't matter for what we're talking about. When we're talking about legal disputes, when we're talking about disputes that might end up in a court, we are almost always talking about money. At the end of the day, courts are concerned with, can I give you money? That's the main thing they can worry about. Most of the other stuff, it's just not within the realm of things that we get to think about. even though the dispute is ultimately for the court, can I give you money? Underlying the dispute, there's almost always something else. If a matter is going to go to a lawyer or a matter is going to go to a court, if it's just about money, you guys are going to settle that out without needing to get me involved. If it's very simple, they didn't pay and I think they should pay, and that's all there is to the case, you're going to be able to resolve that. But almost always there's something else going on there. One of your employees was mean to them, and so they don't want to pay. That happens all the time. Or they don't think the work was done right, even though it's exactly what you quoted. That comes up a lot. And so you need to remember that even though this is about money, underneath it all, there's something else, and you really need to figure out what that is, what the underlying dispute is, because that's going to help you resolve it. And this is a great place to remind you that the number one tool you can use to keep from having to call me in the first place is communication. Almost always, if a dispute goes forward, it's because both parties stop talking. If you keep on talking to the other side, if you communicate regularly, you're going to save money, you're going to save time, and you won't have to get me involved. So I always encourage people, make sure you're talking to them. It's very easy. You have a dispute with somebody, you don't want to talk to them anymore. Maybe you don't have something to say. You say, I'll call you on Monday. Monday comes, you don't have anything to say. So you say, well, I just won't call them. I'll wait till Tuesday. And then it's a month later and you get served with a lawsuit and you wonder what happened. So try to remember to keep the communication going. That's really the main way you're going to stay out of these situations in the first place, because nobody wants to end up in court. And so as long as things are working forward, most people are going to hold off. So, but regardless of what happened, a dispute has come up. You're in a situation, you're looking at it, you're having a fight with one of your customers, and you're starting to think something bad's going on here. Maybe I'm going to end up in court. What do I do? Well, the first thing you need to do is go and read the contract. I know this sounds very basic. Half of you are probably rolling your eyes right now. Of course you knew that. But then you're going to sit back and think, well, okay, let's talk about the contract. I pulled this off of a website 10 years ago, and I haven't looked at it since. And I hand it to all of my employees, and they have somebody sign off on it, right? That if you're a small business, that's most of what your contract, even if you're a big business, that's most of what your contracts are. So when a dispute happens, actually pull out that contract and sit down and read it. And maybe the contract's your lease. Maybe your contract's, the service contract with the customer. Maybe the contract's the contract with your credit card company and they're initiating a chargeback. Whatever it is, actually pull out that contract, look through it, take some time to read it, figure out what it actually says, and look for sort of problem areas. Are there things in it that are actually problematic? A few things that come up pretty regularly when dealing with consumers is you'll look at a contract and you'll suddenly realize it never got signed. You have a contract, you tell your employee, go out, make sure you sign it and they sign it. And then you get, you do the work, you get to the end of it, you pull it out, and there's no signature on the contract. They just didn't do it. Happens all the time. You can get around that, but you need to know it up front that it's happening. You don't want to figure that out in court that they didn't get the contract signed. What about the work? Does the contract say what work is supposed to get done? If it does it say accurately what work is supposed to get done? Because a lot of the time in the course of dealing, you'll change what that is. You'll give an initial bid, and that's the contract document you're working for, and then it changes, and you never actually document those changes. What about the payment amount? Sometimes the payment amount has changed over time. Sometimes your employee you just wrote it in incorrectly. And so you'll have a job, it's supposed to be $10,000, and the employee wrote down $1,000. Well, that makes a pretty big difference, doesn't it? And so you need to know that up front. And again, all of these things can be corrected for the most part, but only if you're aware of them. So you need to make sure you handle it up front. Another major thing you need to keep an eye out for is, does the contract say anything about how disputes are supposed to be handled? A lot of contracts will have in there now communication rules. If you are sending a communication to the other side, how does it have to be sent? A lot of times it says it has to be sent in writing. Sometimes it says it has to be sent in writing, certified mail, return receipt requested. You need to make sure that you pay attention to those lines and that you do exactly what it says. Strict compliance is the best course of action. So you need to make sure that if the contract says, we need in writing that there's a breach and we need an opportunity to cure, then you need to make sure that you follow those instructions and don't just give them a phone call. Also, this is a great place to start looking for any dispute resolution rules they have. A lot of contracts today have arbitration clauses that says if there's a dispute, it has to go to an arbitrator. Other ones say if there's a dispute, it has to go to a mediator. We'll talk about that a little bit later, but you need to, right at the beginning, need to know that all this stuff. So pull out the contracts, figure out what's actually happening in the case. Contracts are important. It's basically private made law between you and the other sides, and courts will uphold that law. Almost always. There are weird sections. So make sure you know it. Then go and pull up the other documents. Because if you've gotten in a dispute with this person, there's a very good chance you have a bunch of other documents sitting around that are related to this that aren't part of the contract documents. So you've been texting with the guy, telling him how you're going to take care of this problem for him. Or he's been texting you, threatening to kill your cat. Whatever it is that's been going on, you need to make sure you get those documents, assemble them, put them together. You need to look through those documents and see, did I agree to do something other than what's in the contract? Because sometimes things will be going forward and the guy will say, okay, well, we agreed to do X, will you also do Y? And you'll say, sure, I'll take care of it. Now, again, that may or may not be legally binding, but you need to be aware of it at this point. After you have all the documents together, you need to ask yourself, what are the actual damages in this matter? What is this case worth? So what does the other side want from me? What do I want to give them? And start thinking about what it's going to cost me to get out of this. Now, sometimes this is very, very easy. Sometimes you did work for a customer. You presented them with a bill for $5,000. They didn't pay the bill. What are your damages? It's $5,000. That's not that hard, right? Maybe you can come up with some other numbers, but it's basically $5,000. But sometimes it's much, much more difficult. Sometimes you will have built something for the customer and it's broken and it's injured the customer. What are the damages in that case? I don't know. And you probably don't know either. And if you can't figure out what the damages are in a case, you need an attorney. Just bright line rule right there. If you can't figure out what's going on in the case, what the damages are, talk to an attorney. Next thing you need to do always is look at your insurance policies. Insurance has done an amazing job. We all know we need it and we all hate to use it, right? So we just pay our premiums every month and never make a claim on it. That's more or less what most of us do. But when a dispute happens and it starts getting serious, you need to pull out that insurance policy, look at it, and I'll just be honest with you, most of the time you won't be able to understand what it says. They're written for lawyers, they're not written for humans. And so you need to take it out, look at it, see what it says. If you think a policy might apply, go ahead and contact the insurance company and talk to them about it. Because insurance company has, generally speaking, has an obligation to defend and an obligation to indemnify. They have an obligation to provide you with an attorney in addition to paying the claim. And so it's good to get that attorney early on if you're entitled to it and it's a serious dispute. Another thing you have to keep in mind is insurance companies don't make money by paying out claims. They make money by denying claims, right? And so if you give them a reason to deny the claim, they're going to deny it. And one of the main ways, one of the many reasons they deny claims is they don't feel like you notified them in time and you took actions that were damaging to your insurance claim. If you do that, lots of times they'll try to deny the claim. So if you think an insurance policy might apply, notify them early. Make sure you get a coverage determination from them in writing. That can be important for later. And then you need to decide if you want to hire an attorney. Do you need an attorney? Yes. Thank you for coming to my talk. Sorry, that was a bad joke. As a lawyer, I have to say yes, you need an attorney. This whole talk is about when you might not need an attorney, but obviously having an attorney is good. If you ask a plumber, do you need a plumber? He's going to say yes because he likes to eat. Same thing for an attorney. I like to eat, so yes, you should hire me. But what should you start thinking about when you're thinking about, do I actually need an attorney in this case? First off, damages. We talked about you need to figure out what the damages are. This one's simple. The higher the amount of damages is, the more likely you need to have an attorney, right? And I'm going to give you a bright line rule right here. If it's above $20,000, you need an attorney. The reason I say that is the only time you should defend yourself, and we'll talk about this in a minute, the only time you should defend yourself is in justice court. And justice court can only hear cases up to $20,000 in value. So if you're below $20,000, you can consider defending yourself. If you're above $20,000, you really need an attorney because you're not going to be able to understand what's happening in a court. Also, if you can't place a value on the case, like I said earlier, get an attorney. If you don't know enough to figure out what's actually happening, you need somebody who can understand that. Next, you need to ask yourself, am I okay with losing? Now, this seems like a funny question. None of us like to lose, but a lot of the times when you're dealing with the lawsuit, sometimes, yeah, you're okay with it. Sometimes it's a case over $50. You know, you're fighting with some guy, it's $50. You don't really care what happens. So you're fine with it going on. Or maybe you did something wrong and you know you did something wrong. You don't think you should lose the case, but at the same time, you can understand if a judge feels that way and you'll pay it off. You just really want somebody to hear you out. In those cases, maybe it's okay to defend yourself. But if this is a case, and this happens sometimes, where the amount involved or the principal involved is so much that you cannot imagine losing, your business is going to go under, or you're just not going to be able to handle it if you lose, then you should get an attorney. I can't guarantee you're going to win, but I can certainly help you. The expression is that a good lawyer can't win a bad case, but a bad lawyer can lose a good case. So I can help you have a better chance of winning. I can't guarantee anything, but I can certainly make it better. Now, quick side note, if you're okay with whatever the outcome of the case is, if this is one of the reasons why you're okay with not getting a lawyer, probably go ahead and try really hard to settle that case, right? If you are okay with paying the guy 100% of what he's asking for, then just pay him 100% of what he's asking for, right? No reason to get an attorney involved. What about this? If the other side has an attorney, get an attorney. That's a simple enough rule. We can make things spin around in ways that you're not used to. It's not really a fair fight when an attorney's on one side and there's not one on the other side. So for the most part, if the other side has an attorney, go ahead and get one too, because it's going to help a lot. Do you actually understand what's going on in the case? Now, sometimes it's simple, sometimes it's complicated. Sometimes it's breach of contract. It's very simple. They didn't pay, or I didn't pay. You know, that's very simple. And sometimes there's some sub-factual issues, but do you understand the legal issues? So if it's just simple, you can say, yeah, I understand it. This is a breach of contract. I know what it is to breach a contract, fine. But what if it's a DTPA issue and they're suing you for for breach of the implied warranty of good and workmanlike quality? Well, maybe you understand that. Maybe you don't. What if they're suing you for some sort of UCC violation and acceptance of irregular goods? Well, the crazier words they use, the more likely it is that you probably should get an attorney to help you out, at least understanding what they are. Do you have time for this? Lawsuits are a pain. They take a lot of time. They take a lot of energy. You're running a business or you're involved in a business somehow, you have social commitments. You need to ask yourself, am I ready to drop all of that and focus on a lawsuit? Sometimes it's yes. Sometimes, you have holes in your schedule, you can work it out. Sometimes you realize this just isn't going to work. And finally, and most importantly, at least to me, do I still want to deal with this person? When you get in a dispute with somebody, sometimes it gets pretty nasty pretty fast, right? They start yelling at you, insulting you, sometimes threatening you. How do you deal with that situation? Well, one of the easiest things to do is just go hire a lawyer, because once a lawyer's involved, they have to deal with the lawyer, not with you anymore. So they're no longer allowed to contact you. All communications have to come through my office. So then this happy woman, she becomes my problem, not your problem. And I will tell you, that's one of the biggest selling points when I talk to a lot of small businesses, is I can tell them, you don't have to worry about this anymore. This is now on my plate. I'll keep in touch with you. We'll talk. If we go to trial, we'll talk about that a lot. But for the most part, you can kind of take a back seat. You're no longer having to deal directly with this person. Okay, so you went through this. You said, yeah, all that's fine. I can handle this matter. And what I'm going to do is I'm going to be responsible. I'm going to communicate with them. I'm going to sit down before it goes any farther, and I'm going to work this whole thing out. So if you choose to do that, and that's the right thing to do, you don't just want to go off and file a lawsuit. You want to try to work things out. If you choose to do that, be careful. The number one rule for negotiating any sort of settlement is try to get everything in writing. When you talk to someone, when you have a phone call with someone, follow that up with a written description of what you think happened. We had a great phone call today. We discussed that I would pay you $5,000 and you would go ahead and release me from any liability. We're going to finalize this on Tuesday. Just write that out and send it to them, because people frequently have very different memories of what happens during a conversation. And you want to document everything that happens in this case. Because if it's at this point in a dispute where you're trying to reach a settlement, there's a decent chance it's going to end up going to court. And so you want that written out because all that is evidence of what happened, what parties were thinking. Now, remember, and this is an important place, you've all heard this before, I hope, anything you say can be used against you. And the worse it is that you said it, the worst thing it is you said, that's the one they're going to keep their hands on, right? So never say anything that you would be embarrassed to say in front of your grandmother. I had a case go to trial a couple of months ago. It turns out my client, we ended up winning. It was a fine case, all of that. But my client may or may not have texted to the other side, "Hey, your mama a hoe." And it turned out the mother had died about a month before that. My client didn't know it, but that came in at trial. And I very much wish that he hadn't said that. But I mean, it turned out okay. But again, that kind of stuff, even though it seems silly, that can hurt your chances moving forward. So always ask yourself, my policy is I always write something and then I let it sit, normally overnight if I can. Then I come back the next day and read it again and say, do I really want to send this? If you do reach a settlement agreement, great, your case is over with. Make sure you get the settlement agreement in writing. You need to make sure that it's signed by all of the parties. And at the minimum, what you want to include in your settlement agreement is you want to identify the parties at the top, state exactly what the dispute was. Jim said that I gave him the wrong color shirt. That's fine, just whatever it is so that we know what you're talking about. Then recite the date, time, place, any information you need to, method about how you're settling this. I agreed to give John $5,000 via certified check on Tuesday, December 4th, delivered to, whatever the address is by certified mail. Spell it out exactly because we don't want to dispute over that part. And then finish it just saying that both parties have agreed that this finally resolves all disputes between them. And you want to make sure you include all of that information at a minimum, just so that any person coming looking at those documents later can figure out what you were actually talking about. Because a lot of the times, you'll say, well, no, I paid Jim $5,000 to get rid of that. Jim goes, no, you didn't pay me $5,000 to get rid of that. You paid me $5,000 so I could go and buy materials. And then, where are you? Who's right? Nobody knows, and the judge certainly doesn't. Okay, so that didn't work out. You weren't able to get it settled. So now you've decided that you don't want to hire a lawyer. Now I want to start here. Most cases that come into my office, they come in at this point. The case is not worked out. Somebody's got to file a lawsuit. So it's not too late. Just because you decided to handle that first pre-suit part on your own doesn't mean you can't hire a lawyer now, but you're of course not obligated to. So these are just some general guides for what to do if you decide not to hire a lawyer and to continue forward. First, the trial notebook. I'm going to reveal to you a great secret of lawyers that, if my connection disconnects now, it's because the Bar Association has come and tackled me. It's a very great secret. It's called the trial notebook, and it is a 3-ring binder. That's it. It's not really that exciting a secret, but it is actually a very powerful tool. The trial notebook becomes a great tool for organizing before the trial, making sure you understand what's happening, and then it becomes something you take with you into the trial that contains all the information. So what is it? Well, you take a 3-ring binder. You put dividers in it and you label the dividers. These are the ones I use for small claims court cases. There's more if you're dealing with larger cases. You divide them up: analysis of the case and opponent's case, section 2, proof checklist, section 3, opening, section 4, witnesses, outline, section 5, documents and exhibits, section 6, closing. That's simple. And then right at the beginning, you start preparing your trial notebook. One tool, one general bit of advice that we use as lawyers, and I'll pass on to you, is the best way if you think a matter might go to trial is always start preparing it as though it's going to trial. And this is one of the main ways you do it. So what do you actually do? Well, you take out your trial notebook, you open it up, you go to analysis, and now you generally do this on a computer and then print it out. But you go to analysis of the case, opponent's case, and you sit down and you write out what you think is going on in your case. I normally start with a timeline up at the top saying, this happened first, second, third, fourth, fifth. That's normally very helpful, helps you organize the case. And then I'll write out briefly what I think happened. Jim, we entered into a contract on December 4th with Jim to do X. we sent a demand for payment now. Jim didn't do this in this date. This didn't happen. We talked on this date. You write it out and you analyze the case. And then below that, you put bullet points of what you think are the major factors that are going to come up in your case. That's the analysis of the case. And you work on it throughout the process. You come back to it as you get more information. Then, and this is very important, you do the same thing for the opponent's case. You sit down and you think about the other side is fighting me on this. So what's going on? What is the case from their point of view? If you ever walk into a courtroom and you think the other side doesn't have a case, you're doing it wrong. You have misunderstood something, because nobody goes to court for fun, except for me. But no normal person goes to court for fun. So you need to do the same thing for the opponent's case. Figure out what the weaknesses are. What are they saying? Are they saying, even though you disagree 100%, they're saying you lied about the color? Well, that should be on the section of the opponent's case. You need to make sure they understand that. Next, you do the proof checklist. This is the second section. In law, most things fall under, or everything falls under, what we call a cause of action. So it's either a breach of contract, a fraud, a DTPA violation, whatever it is. You figure out what yours is, say breach of contract, and then you go Google
really
on.
quick. We had a question about to define what a DTPA means.
Oh, DTPA is Deceptive Trade Practices Act. It's a consumer protection law that's designed that basically if you do anything that the legislature has established as being deceptive towards a consumer, then you can get sued under the DTPA. It provides for damages, attorney's fees, in certain situations, treble damages, which means 3 times the amount of actual damages. And it covers a whole lot of the stuff that small businesses do on a daily basis. If you ever deal with a consumer or a business that has under, I think, $10 million worth of assets, you're possibly covered under the DTPA. So good one to keep an eye on, worth Googling. But so onto the proof checklist. So you look online, you find your cause of action, and it's going to have elements. It's going to say, breach of contract. Does a contract exist? Are you a proper party to sue? Did you perform under the contract? Did the other side breach the contract, and damages? And you just write out those elements, put a little place for a check mark in front of it. And then what I do is behind that, for each element, I just put a parentheses and put in what evidence I plan on offering for that. So does a valid contract exist? And then I'll put contract, because that's my evidence. Did we perform under the contract? Photographs, Jim's testimony. Did the other side breach? Demand letter, text messages. And what damages, and then estimates from a third party or the contract or whatever it is. And that's incredibly important, because that's what the judge is going to be looking for if you end up in trial. And a lot of the times what you'll realize when you prepare that is there's an element in here that you really don't have great information on. You really don't have any proof that you did this. Damages comes up a lot. A lot of people, especially when they're handling it themselves, they don't think about damages as something that they know something bad happened, somebody else should figure out damages. Well, it's your job to prove that. So you need to make sure that you have evidence. Next section is your opening statement. Do that last. Even though it's the next section, it's just they do it in order. Then you have your witnesses and outlines. This is where you figure out what witnesses you're going to be calling, and then you figure out a couple of questions you need to ask them. Generally, you're only looking for each witness at bringing out like 3 points. You want them to tell a little background and talk about a couple of things. And you just put bullet points down for what questions you plan on asking them, divided up by headings of what the purpose of those questions are. You do an outline for each of your witnesses and an outline for every witness you think the other side is going to call. Documents and exhibits is where you print out your copy of the different exhibits you're going to offer in court. You stick them in the folder so that they're available. Put a little checklist at the front with the name of each exhibit. And then closing, just put a couple of loose sheets of paper in there. We'll talk about why later. Okay, now after you understand the case a little bit better, go look at the contract again. See if you have a clause, again, for alternative dispute resolution, and think about if you want to send this to alternative dispute resolution instead of to court. For example, mediation. Mediation is where you have a neutral third party sit down with both of you and try to help you reach an agreement. That's what mediation is. It's non-binding. It's very useful. It gets rid of most of the cases, and it tends to be affordable. So I'd highly recommend look at the contract. If it says there's a mandatory mediation, send it to mediation. If there's not, consider talking to the other side and getting a mediation out of the way anyway, because it will save you money in the long run. Does the case require arbitration? Arbitration is basically a private court system that you both agree to. And in your contract, you can say, yes, we agree to arbitration. And that means that theoretically, you're not supposed to file it in court. Technically, you can still file it in court. Then the other side has to request that you remove it. And honestly, most of the time, if I'm talking about a small claims court case, I'll just file it anyway because the fees are minimal. And if the other side wants to pull it to arbitration, they can file a motion on that. Then after you look at that, you say, okay, no alternative dispute resolution. What court am I going to send this to? Well, Texas decided to have an incredibly complicated court system, and we have, bifurcated Supreme Courts and all sorts of weird stuff like that. So there are generally 3 civil trial courts we're going to talk about. We're not going to talk about municipal courts right now. 3 civil trial courts: Justice Court, County Court at Law, and District Court. For any case that we're talking about, a case under $20,000, you could probably file this in any of these courts with a couple of exceptions. But the only time you are going to be interested in representing yourself is if this is going to justice court. And the reason for that is because one of the main ways we make you hire a lawyer is because we speak a weird language in a courtroom. We have to follow the rules of evidence and the rules of civil procedure, which require all sorts of strange things: proper filings, proper words used, predicates laid, all of that stuff that's really complicated and that you, unless you're a lawyer, you don't understand and can't do. You could do it if you spend a lot of time learning it, but it's not that easy. The county and district courts, they use the full rules of evidence and procedure. You don't know them, so you don't want to be in those courts. If you're representing yourself, justice court is where you want to be, because justice court doesn't use the rules of evidence and procedure. They have their own little section. It's the 500 section of the Civil Procedure Code. And it basically says the rules of evidence and procedure only apply as much as the judge thinks they should. And the judge doesn't think they should. So they never really apply in their full regard. So that means it's really designed, justice court is designed so you can represent yourself. So that's why I keep on saying only justice court. If you get served in a lawsuit and it's $5,000 and you go, man, I'm at $5,000, I can do whatever, and you see that they filed it in the district court, don't represent yourself, because you're still bound to those full rules of evidence and procedure. You need a lawyer. So justice court is an election you make, the plaintiff makes when they file the lawsuit. Justice courts hear 4 different types of cases. We only care about small claims cases. Those are the cases under $20,000. They also hear debt claims. You might care about that if you get sued by your bank. Debt claims are claims bought by financial institutions trying to recover money. They're a lot like small claims court cases, except for they require additional things to be filed at the beginning to answer certain questions about who the original creditor is, how much money we're seeking, things like that. JP courts hear eviction matters. So again, you might care about that if you're getting evicted for non-payment of rent on your office, or you're a landlord and you're having to evict somebody. You're probably used to JP court by now. There's also a weird one called repair and remedy cases, which we really don't care about. Okay. Major question you need to make sure you understand: if you're filing a case in justice court, which justice court do you file it in? So how justice court works is every county has one, and most counties have more than one. Ellis County is divided up into 4. Tarrant County and Dallas County have a lot more than that. And what they've done is they've just divided up the map and drawn them into different precincts. You need to make sure that you file it in the right county and the right precinct. And you file it in the county and precinct either where the dispute arose or where the defendant resides. Those are your general options. There's some weird rules out there that make it more complicated, but generally, if you file it where the dispute arose or where the defendant resides, that's fine. So let's say that you have a business here in Midlothian, you have a client up in Dallas, you drove up to Dallas, you did work in Dallas, you signed a contract in Dallas, the defendant lives in Dallas, you come back down here and he doesn't pay you. Where do you need to sue him? Well, you got to sue him up in Dallas, right? Even though you're here in Ellis County and it would be much nicer for you to be able to do that, you have to sue him in Dallas. And that's actually why they did it, is because they didn't want people to be able to pull defendants into other counties and force them to defend in an unfriendly place. So that's the general rule. That's what you should look for. Now, who is a JP? I've talked about a JP a lot. If you're not familiar with them, it's a very interesting lower judicial office in Texas. These are elected officials, like almost every judge in Texas, not municipal judges in many cities, but everyone else is elected, and they are not required to be an attorney. So the judge sitting on your case very likely did not go to law school. And that comes as a surprise to many people when they're sitting there and, you know, the judge doesn't necessarily understand all the legal parts. But I actually had a case in North Tarrant County where me and another lawyer were going at it for about half an hour. And finally, the judge just stopped us and said, I'm sorry, I don't understand any of this. You guys need to take this into county court. I'm just going to rule in favor of the defendant. And you can appeal it up. So, you know, it happens. But they're not required to be an attorney. Many of them I've noticed have law enforcement backgrounds. So if you want to know about your JP and if you're filing in a court, if you're looking at going to court, this is a good idea. Google them. They're public figures. You can look them up online. You can figure out who they are, what their background is, what kind of things they might like, what political party they belong to, because some of that stuff can make a difference in how you want to present your case. Before you sue, before you take the step of filing a lawsuit, you need to ask yourself a couple of questions. One, if I sue them, are they going to sue me back? We call that a counterclaim. A lot of the times you have something like they owe you $3,000, but maybe you might owe them $5,000. Does it make a lot of sense to sue them? No, because they're going to, at the end of the day, they're going to recover $2,000, right? This comes up quite a bit. People get angry and they forget that, well, I didn't pay them because I got angry at them about this work, but yeah, I still owe them $5,000. Well, sometimes it's better to just kind of sit back and see what happens, because you don't really want to be in that situation where you go through all of this and then end up owing them money. Sometimes you need to do it anyway. Another big one, can they actually pay a judgment if you get it against them? In Texas, it's very hard to collect a judgment. So most of the time you end up with a pretty piece of paper. What you're looking for in this process is to get them to agree to pay you, even if it's a lesser amount than the amount you feel you're fully that belongs to you. Because if you're suing an individual, they have homestead protections that covers almost all of their assets. And so if you get a judgment against them, there's a very good chance you're never going to see the money. Now, there are exceptions. There's different kinds of mechanics, liens, and things like that you might be able to use if you follow the rules correctly. And there's, you know, if somebody has multiple properties or a lot of cars, or if you're suing a business, you can generally check that box. And again, you know, check one more time. Do you think you can work this out before you file the lawsuit? Okay, so you've decided you got to file a lawsuit. What do? You get your documents together. You go to the courthouse. And this is going to be the justice courthouse. Justice courts, like I said, they divide the county up. And so the JP courts are there's generally one at the downtown courthouse, and then the other ones are scattered throughout the county. So you need to look up the address for the JP court you're actually filing the suit in. Then you either go online or go to the courthouse in person and see if they have a form. This is a form, I pulled it from Harris County online. There's forms for most larger counties. Most smaller counties generally have forms, but you have to go to the courthouse to get them. And you just ask for the petition form for a small claims lawsuit, and you fill it out. It's pretty simple. You put the names of the parties at the top. The court will fill in the cause number. You put your name and your address, and then you put in the defendant's name and address. Now, that's a hard one because you actually have to figure out their name and address. Then you have to do the hardest part of the petition, which is you have to figure out their address for service of process. So what does that mean? So when you serve somebody, you have to make sure it gets to the right person. Now, it's pretty easy if you're suing an individual, right? You have to get it to that guy. But what if you're suing a corporation? Well, what you need to do is you need to go to the Secretary of State's website, or you need to call the Secretary of State, give them the name of the business, and then get back the name of their registered agent for service of process and the address. It's not hard to do, but you need to make sure you do it because you have to get them properly served. So you get that information, then you fill out very briefly. You don't have to do a whole lot of work on it. What your cause of action is. What are you saying in plain language that they did wrong? It's justice court. It doesn't have to be fancy. They didn't pay their contract. They didn't do the work right. Then relief requested. How much money do you want? Then you sign it, fill out your information on the bottom. You have to pay a fee. Fee in Ellis County is $138. That's fairly close to standard. You're paying $48 to file the case, and then $90 to have the constable go out and serve it on the other side. Now, I don't want to get too far into it. Technically, you can hire a private process server to do that for you. I generally, especially if you're recommending it, if you're doing it yourself, just have the court take care of it. You'll have to pay. It's about the same cost. It will generally work. Sometimes you want a private process server, especially if somebody's hard to get a hold of. So let's jump to the other side. So now you're not in the driver's seat. You got sued. A dispute happened. They pulled the trigger first. You've just been sued. So what happens? Well, you get a sheet of paper either delivered by a constable, which is a law enforcement officer, normally in uniform, or a private process server, sometimes through certified mail. You open it up, and at the top, you have a citation. At the very top, it says very nicely, "Greetings, you have been sued." Because in Texas, we are very personable like that, right? Greetings, you have been sued. And then it explains that you have 14 days to file your answer. It needs to be in writing, it needs to be sent to the court and to the other side. A couple of notes very quickly. When you're sued, you're generally going to be sued by a constable, process server, certified mail. However, sometimes you're going to get an email that says courtesy copy of the lawsuit that's been filed against you. Or you're going to get just a regular mailing. Now, those might not be sufficient to constitute service in all cases. But what you need to do when you get that is take it, call the court, and find out if this lawsuit has been filed, and keep track of it. Because what you don't want to happen is that they don't serve you properly, or that they can't find you and then they use alternative service. Because in some cases, they can just serve the Secretary of State and then you're served, or they'll publish it in the local newspaper and then you're served. And then you end up with a judgment against you for tens of thousands of dollars that you didn't know about because they never served you in person. So always take any notice of a lawsuit seriously, even if you're not sure if it was properly served. Now, this is a great time to remind you, I've mentioned a couple of times the Secretary of State, if you are incorporated, please take a second right now and make sure that on your articles of incorporation that you have the appropriate agent for service of process still listed. So when you signed up, when you sent the documents to the Secretary of State, you included the name and address of the person who's authorized to receive lawsuits on your behalf. And then you moved, right? And now that address no longer goes anywhere. So as far as anyone in the state is concerned, they can serve this vacant building. And as far as the law is concerned, your corporation has just been served. That's not a good thing. I had a case happen a couple of years ago now where the company called me. I'd helped them with a couple of small things. And then they called me in a panic later. They had moved their office, a dealership, from one location to another location and hadn't updated it for 2 months, hadn't updated their address for service in 2 months. And during that time period, someone sued them, got a default judgment against them for $200,000 for a case that was worth maybe $20,000. And now they had to go into court and fight to get that old lawsuit thrown out and figure out how to move forward. And it cost them a whole lot of money to get it done. So just go and check that if you're incorporated. Make sure that you still have that information current on your documents if you're incorporated. If not, then make sure you have your DBAs on file properly. After you're served, you have 14 days to file an answer. Generally, it can be shorter for eviction matters. It's longer in the big boy courts, but 14 days is general small claims court in Texas. What goes in an answer? Texas is great. Texas uses what's called a general denial. Basically, anything that says I disagree is fine. There's some great cases out there about people who wrote something on a napkin and filed it with the court, and that's considered sufficient. You don't want to do that, but generally you can find the form at the courthouse again. You put in your name, and then it just says defendant denies all the allegations. And you file that with the court.
Yep. We have one more question on the chat. I'm going to try and make this kind of general because I think that'll help everybody else. In a mediation case, this person is asking, what is Rule 11 based on Texas rules of civil procedure? Basically, it sounds like they came to an agreement for a dollar amount, but there were some conditions attached that they did not agree to, and what to do next coming from a mediation agreement.
Okay, so a mediation agreement, Rule 11 of the Texas Rules of Civil Procedure is an agreement that says that if you get something in writing signed by the parties, it's binding for that lawsuit. That's so basically it means write it down. It also means that other stuff isn't necessarily binding. So if you come into a mediation, if you reach an agreement, I mean, if you signed it, if you agreed to it, you need to follow through on it because that's the agreement. You can back out of it, but then you're putting yourself up for a breach of the new contract. So sometimes that's fine, but if you enter into an agreement, because the idea is that in a mediation, in a good mediation, the end result is a contract, a Rule 11 agreement, but a contract for settlement of the case, and you're bound to the terms of that agreement. So that's really the entire purpose of a mediation, is to get the parties to come to an agreement. Now, if something crazy happened, if the mediator put stuff in, if you didn't sign it, that's a different issue, but generally that doesn't happen.
Okay, I hope that answers that question. Follow up with more if y'all need more answers or more clarification on that, or you might reach out to Jacob if it gets really specific.
Okay, so like we were saying, answer is very simple. You can find the form at the courthouse, you fill it out, send it in, make sure you send a copy to the court and to the other side, serve it on the other side, certified mail, return receipt requested. One quick note, if you're counterclaiming, you might have to have a little bit more of a substantial form than that to fill out your counterclaim, and you'll have to file a minimal fee, but you won't have to file the service fee. So you'll just have to file the $40 and not the $90. So that's an answer. Answers are easy. And then what happens to your case? It disappears, unfortunately. It goes into the black hole is what I call it. After you file your case, it's with the court now, and it's going on the court's time. And how much time the court takes depends on what the court's doing. Normally, JP courts are fast. I just had a JP court case where it took 2 years for us to get our trial setting, and then COVID hit and they closed the court down. And ultimately, we ended up just settling it because we all got so frustrated with it. But so normally, you're just sitting and waiting for the court to tell you when you need to go in and do the next thing. The kind of stuff that might happen before you go to trial, there's a few things that happens. First off, discovery. In the county court and district court, there's a lot of discovery. That's what we're doing during this downtime. We're asking questions to the other side. We're getting documents from the other side. We're interviewing the other side. We're figuring out the case. In JP court, you don't get discovery as a matter of right. In JP court, you only get to ask questions if the court agrees that you can ask those questions. You have to file a motion with the court and ask permission. And every time I've done this, the court has granted my discovery request, but informed me they don't like allowing discovery. So I believe them. For the most part, they don't want you to ask discovery questions. So for the most part, this isn't available unless you have a very specific reason for it. So reasons that you might do discovery. The other side says that you entered into an agreement with them and you don't have a copy of the agreement. So you ask the court, give me a copy of the agreement. The other side says that you caused $20,000 worth of damages, ask for a copy of the estimate. You know, things like that where you legitimately don't have a copy of it, don't have access to it. You have to ask the court, and please ask the court, because it's really painful showing up the day of trial and figuring out that they have evidence that you didn't know about. That's never much fun. It's what JP is like. It's not what lawyers like. So, you know, ask the questions if you can. If there's something you think you want, ask the JP court for permission to serve it. If they say yes, you can serve it. If not, you can't. But, you know, it doesn't really hurt to ask. You're not going to make the JP mad. They really won't remember one way or another. Another thing that might happen before you go to trial is a pretrial conference. This is used at different, it's more at the more crowded courts. JP Court in Arlington is one of the most crowded, most busy JP courts in the country. They also, interesting side note, is it's where Judge Judy gets most of her cases from. So that's fun. So the JP Court in Arlington is very busy, so they use pretrial conferences. What is a pretrial conference? They send you a notice that you have to show up at the court at a certain day for a pretrial conference. Pretrial conference is not a conference. The idea is that if you show up to this conference, the judge will talk to you, kind of talk about the case some. If you don't show up, you lose. And the judge enters an agreement for the other side. If nobody shows up, they just dismiss the case. And the idea is that a whole lot of cases get filed and people don't really want to follow through with them. And so the judges will file these early on in the case. Normally, you know, a month or two after you file, you'll have the hearing and you show up. What happens at these? If you both show up, The judge will talk to both of you. You can talk about if you want to file any discovery questions, get the judge feelings on that. You can also, the judge will ask you if you want to go to mediation or if you want to step over into the side room. They do that a lot and talk about the case and see if you can reach a settlement. So always show up to a pretrial conference. It'll say on the form that they'll dismiss it if you don't. So take that seriously because they will. But I like pretrial conferences because it gives you a chance to talk to the other side. Mediation, again, this is something that may or may not happen. Courts used to order it a lot. They changed the rules so that it's harder for courts to order it, but it's generally a good idea. Again, impartial third party sits down with both of you and tries to settle your case. There's a cost involved generally, and it can vary a lot. I'm on the board for Dispute Resolution Services. We were the nonprofit, low-cost mediation provider for Tarrant County, and we charge $15 a party. Then the county decided to take it in-house, and so nobody's charging anything, or I don't know what they're charging anymore. Generally, you'll see up to $250 per party to do it. For bigger cases, you'll see, $2,000 per party, $5,000, $10,000. But for these smaller cases, this is generally the range you're looking at. You'll get 2 to 3 hours to sit down with the JP and talk about it. Again, if you do a mediation, both sides have to agree to the settlement. The mediator can't force a settlement. The mediator isn't in charge. They're not the judge. They're just listening to the two sides, helping you get together. Treat mediation seriously. Come with all your documents. I had a case I was mediating probably a year ago now, where we were dealing with the landlord. The landlord said the tenant destroyed everything, and he has pictures. I asked to see the pictures, and he told me I was stupid for asking for them. I'm not sure why I was stupid for asking for the pictures. I guess he just didn't have them. I'm still bitter about it, as you can tell. But so come prepared with all your documents. Even though we can't make the final decision, we get a chance to kind of help push, and the documents you have help us do that. And mediations are very important because it's really your last chance to resolve this a way you want. You are not going to be happy if you go to court. I'm just going to say that outright. Courts are never fun. Nobody feels good. You talk about your day in court, but it's a scripted exercise to a certain extent. Mediations are really your chance to get an agreement everyone can live with and move forward with. So please take them seriously. It's a great opportunity, and it's something that's really an important part of this dispute resolution services now. Okay, but none of that worked. You're at trial now. What happens? Court's going to send you a notice. Show up at a certain day at a certain time. Make sure you show up 30 minutes early. Now, most JP courts before COVID, now it's all online, which is just weird. But I'm going to talk about the normal world that will hopefully happen sometime soon. Normally, they just do a cattle call. They just have 24 people show up at the courthouse at the same time to hear their matters. And you just have to sit there and wait until the judge calls you forward. And if you're in a lawsuit and you're representing yourself, that's going to be a while. Normally, they'll take undisputed matters first where one side didn't show up, and so they can get those people home because it only takes a couple minutes. Then they'll call the ones with attorneys because we're charging by the hour, so they want to let us go home and stop the clock running. Then they'll call your cases and have you come up and do yours. So be prepared to wait. And this is a great time, final check, just because you're in court doesn't mean it's over with. This is a great chance to sit down with the other side again and talk about your case and see if you can reach a settlement. Because right now you're nervous and they're nervous, right? So it's very likely they're going to be like, hey, maybe we don't need to go in front of the judge. Maybe I'll go ahead and take that settlement. So that's a good option right there. Now, when you get to JP court, you're going to notice there are drastically different levels of formality. Because JP courts don't follow the rules of evidence or procedure, they kind of do whatever they want to. And that makes it very confusing. Most JP courts, when you show up, they'll call your case. The judge will just have you come and stand up next to them. And you'll just, stand there at the bar talking to them for a while. It's fun. It's easy. It's very light. But it can get confusing as to what's evidence, what's not. Other times, they'll have you sit at the tables at the back. They'll have you call your witnesses. They'll have the witnesses sit in the witness box. They'll have you ask questions like court you might see on TV. And so the best thing to do is before you go to court, before your trial, remember that these courts are, at least before COVID, were open to the public. So take a day, go show up, find out, call the court, find out what day they're hearing trials, go show up, sit in the back and watch, see what the judge does, because that's going to help you understand what you need to do, how prepared you need to be. Now, remember that your goal in the case, and this is something I've learned from years of doing this, your goal in the case is to make things as clear as possible for the judge. If you're trying to win, you want to make sure the judge has a very clear story they can follow. So you don't follow the rabbit trails off at the other side. You don't get in a fight over what Jim said on the 14th if it doesn't matter to the case. Don't fight over all of these unimportant issues that come up. You stick to the elements of your case. You stick to your story, your theory, your theme of the case. You tell that, and you make it simple for the judge, because the judge is going to be listening to 20 cases that day. He's going to give you 30 minutes to talk, and then he's going to make a decision. So if it's a convoluted case, you're going to have a bad time. If it's simple, you're going to do better. On the other side of that, if you did something wrong and your real goal is to just not lose, maybe get into some fights over irrelevant things. Lay some rabbit trails. See if the other side will start fighting over something else. Make it more convoluted. Now, I would never say to do that because ethics and stuff, but at the same time, if it's a simple case and you make it seem more complicated, if you're in the wrong, it's more likely the judge will get confused and rule in your favor. Just throwing that out there. What do you bring? You bring your trial notebook, you bring all your witnesses, you bring exhibits, 4 copies of it, one for you in your trial notebook, one for the opposing party, one for the court, one for the witness when you call him. So 4 copies. Bring a pen and paper for notes, and then bring anything else you think you need. Because when you're in court, that's your day in court. You don't get another one. So if you think you might need it, bring it. A lot of the time you'll hear people, especially in justice court, go, oh, well, no, I have that document back at my house. I can send it to you. And the judge just has to go, no, that's not how it works. So bring the client file if you have it. Bring the records of communication. Bring the answering machine with the tape in it if you have a bunch of recorded calls you might want to use. I mean, anything you think you might need, bring it. Very quickly, parts of the trial: opening, direct, cross, closing, judgment. Let's see. Plaintiff goes first, defendant second. Very quickly, opening. I want to make sure you understand this, and I'm sure I'm running out of time at this point. Yeah, I got 2 minutes to cover the rest of this, and that's never going to happen. Okay, so opening statement. The judge gives you a brief opportunity to explain your case. And I mean brief. They don't want you to go on for 30 minutes. They'll cut you off. Before this happens, look at your trial notebook. Make sure that you know what happens. The opening was the last thing you prepared, remember? Just do bullet points explaining, not a long story. Don't read from a script. Just say, on 15th, we entered into a contract. On the 27th, we did the work. There were no complaints. We sent demand on the 18th. She didn't pay. We sent another demand. She didn't pay. And now we're here. That's simple enough. Keep it simple for them. Timeline, you want to order this chronologically. You're just telling the story of what happened, emphasizing what you care about. Signpost for the court what's important in this case, and never attack the other side. This is a big deal. A lot of people get into court and think, oh, I'm going to show how stupid the other side is. Judges hate that. Judges hate it when you jump on the other side. Be polite the whole time. Just state the facts. Then you move into the witness examination portion. The plaintiff goes first. The person who brought the lawsuit goes first. The defendant goes second. The plaintiff gets to call their witness, their first witness, and then they give them a direct examination. This is where we ask them to tell their story. And really what it is you are asking your witness to tell the story. A lot of the time that witness is you, and this is one of the most confusing parts about handling a matter in justice court. What's the difference between opening statement and direct? I don't know. Judges frequently don't care either. If you're a JP, they don't frequently do that separately. They'll have you start talking, and then they'll just go, is there anything else you want to offer into evidence? And you're like, I didn't even know we started evidence part of this yet. You said opening statements. That's fine, but you tell your story. If you're asking your witness questions, you just use signpost questions. Okay, what happened on the 14th? Did they pay? Not very specific questions. You don't really want to go too broad, but you want them to tell their story because that builds credibility. While they're telling the story, you introduce your evidence. Did you enter into a contract with them? Yes. Okay. Is this a copy of the contract? Yes, it is. And tell your full story. Don't rely on the other side. Then after direct examination, the other side gets a chance to cross. If you're doing a cross-examination, you get to ask them questions. A couple of key points. Don't argue. If you say, hey, did you tell me that, the wall would be blue? And they go, no. You don't go, well, yes, you did. You just leave it and move on. Never interrupt them. Judges hate it when you interrupt people. Even if they're lying through their teeth, never interrupt. The only questions you should ever ask on cross are leading questions, questions asking for a yes or no answer. Never ask an open-ended question. Say, you know, did you say you'd paint the wall blue? Don't say, what color did you say you would paint the wall? Always ask for a yes or no question. Always lead on cross. If you don't know the answer to a question, generally don't ask it. I say generally, it's justice court. You can get away with a lot, but generally don't ask it. That's a general piece of advice that lawyers give out, have given out forever. Because if you don't know what's going to happen, you don't know if it's going to help or hurt your case. If you don't have a reason to ask a question, don't ask it. Don't give them a chance to offer more evidence. And finally, if you don't have any questions for the witness, just say, Your Honor, I don't have any questions for this witness, and move on. This happens a lot in cases. There's a lot of stories about new attorneys who will go into a courtroom. There'll be a wrongful death case. The mother of the decedent will get up on the stand, and the new attorney will stand up and start ripping into the mom about something. And you're like, there's no reason to do that. That didn't help your case at all, and now everyone in the courtroom hates you, right? Well, that happens in JP court too. And again, don't rely on the other side to prove your case. Don't expect you're going to win on cross. The best thing you can do most crosses is not ask any questions, quite honestly, especially if you're not an attorney, if you're representing yourself. Prove your case in your own elements, let them talk, and if they say something that's not true, have a piece of evidence and say, you said the wall was going to be green, here's an email saying that the wall is going to be blue, right? After you get done with your witness examinations, take a second, look at your trial notebook, make sure that on that evidence checklist, you introduce evidence for all of your elements. The judge will ask you if you have any other witnesses. If not, say no. Then you might or might not get an opportunity for closing. Generally, you won't. Closing is your chance to highlight what happened. JP courts don't like closing because they were in the courtroom the whole time. The case took 30 minutes. Why should I let you have 10 minutes to tell me what I just heard? So if they let you, you can follow that slide. If not, not. Then the judge will issue a judgment, normally right there in the courtroom at that time. For JP courts, they don't, step back, go into chambers and issue it a month later. They tell you right then what happened. They'll generally say, I find in favor of the plaintiff and he takes $10,000 plus court costs and attorney's fees, or I find in favor of the defendant and to issue a take nothing judgment. They'll tell you in court what happened, write it down. Generally, if you're representing yourself, what's going to happen is the court will send out a written copy of the judgment the next day. It'll get to you a few days later, and then you'll have your very fancy piece of paper that tells you that you are now entitled to money, right? Okay, very quickly, because I am completely out of time, but I want to get through this. What happens after you're done? Okay, after you're done, first thing that can happen is either side can appeal it. And if you appeal it, it's a trial de novo. Everything we just did goes away. The difference is it's now taking place in the county court at law, and you now need an attorney. So sorry, all of that's gone. Everything I just told you goes out the window. Now, the good news is appeals are very rare. Less than 10% of cases get appealed. Most of the time, people are just looking for a chance to go into court and share their side of the story. And once a third party tells them what's supposed to happen, they stick with it. But if you disagree with what the judge decided, or if the other side disagrees with what the judge decided, you can file an appeal. You have to place a bond with the court to cover the cost, which can be substantial. Defendants generally have to file double the amount of any judgment against them to make sure they can pay the judgment. If you don't have any money, you can file a pauper's affidavit to get out of having to file the appeal. And then you go up to the county court at law and you start all over again. So that's kind of the bad news. The other bad news, you go through all this, you get a piece of paper. The other side owes you money. The judge said so. You're very happy. The deadline to appeal expires. You go into collections. You go, hey, Bob, give me that money you owe me. And he says, no. Well, unfortunately, as we talked about earlier, collections in Texas is very, very hard. And at this point, probably go ahead and give a lawyer a call. It'll cost you a whole lot less to just have them do collections than it would to have them handle the whole lawsuit. But you're going to have a hard time getting that money unless they voluntarily give it to you. And then let's see, that's it, I think. final notes. If you have any questions about this, of course, you can give me a call. The rules for justice courts in Texas are found in the Texas Rule of Civil Procedures in the 500 section, which is you open up to 500. You can find them online. Every justice court is required to have them available to inspect if you're interested in inspecting them, which you're probably not at this point because I bored you to tears and you're just going to hire a lawyer, which was my evil plan from the beginning. So.
Hey, Jacob. So we have one last question that I did not get to ask during all of that, and that is, with an increase of online sales and services, small businesses are now open to the possibility of needing to sue or being sued with another person who might be out of state for things that are happening in different states. You define, you gave some definition of where to file, obviously within state. Is that how we handle something like that, or how would that go?
Every state is completely different. So if you are involved in a matter involving more than one state or involving a different state, you need to hire a lawyer. And not only that, but you need to hire a lawyer licensed in that other state, which makes it really hard. So for example, if you're involved in a lawsuit in California, I can't help you. So you have to find a lawyer, a California lawyer, to represent you. So, it's a very difficult situation. It's a great question. I mean, you can go to federal court. You don't want to go to federal court. They're mean. But you can go to federal court and handle it with one system. They don't have justice courts, and every state has their own rules for what courts there are, how you file, what level of formality, and the rules of evidence and procedure. So,
okay.
Sorry.
Great. That's a good answer. Okay, I think we are good. That's all the questions that we received in the chat. Unless anyone has anything else, I don't see anything else popping up. So Laura, do you want to transfer us over to Sharon?
I do. I want to thank Jacob. It was really informative and super scary, and really a lot of good lessons in there. I think this video is going to be a keeper for a long time, because somebody's going to say, I remember the chamber did something a year or two ago, and they're going to come back and try to find this. So thank you very much. You've just become a lasting resource to small businesses, and probably generated some clients, even though that may not have been, or maybe that was your evil intent. Yeah, just the thought of representing myself in a JP court is super intimidating. All right, now I did promise everybody who stayed on that we were going to have a brief announcement from Dr. Sharon Price. Sharon, I'll let you take it away. Tell us what's happening, and so how we can be involved.
Hi, we're just really happy that you all joined us today. And I think Allie's going to throw something up on the screen that will demonstrate what I'm going to be talking about for a minute. We are very happy to be offering again the Accelerate Entrepreneurship course, which is in conjunction with our friends at Navarro and Tarleton here in Midlothian at the campus, the higher education campus. And it's going to be starting up in January. And that course is an introduction to entrepreneurship. And we would really enjoy your company there if you would like to attend the course and get some information. If you're thinking about starting a business, or if you started your business and you're not sure you've got all your ducks in a row and you just want to get some reinforced learning, it's a great opportunity. You can see the information here on the screen, and we will be putting this flyer out and some other promotions on this course. But you can register through Navarro College, and the cost is $25, which includes 4 workshops starting January 12th on Tuesday evenings. And the instructors of these courses are all local Midlothian professionals. We've got a legal group, we've got a bookkeeping group, an accounting group, a banker, some marketing folks. And so we just have a wide variety of people who are just interested in providing you high quality information to help you get off on the right foot on your business, and be there as a resource during that course time to just answer any specific questions that you may have. And so you can see the information here on the screen, and again, look for this information through the chamber to be coming out on social media. And if you are not interested, but you may know somebody who is thinking about starting a business or has started a business that needs this, please make sure to share that with them, and we would greatly appreciate it.
Thank you, Sharon. We appreciate it very much. You know, Midlothian and especially the Chamber Board really want us to be known as an entrepreneurial friendly community. And this is part of what the Chamber's Education Committee with Sharon in the forefront are helping to make happen. So some businesses have closed in our city in this past 8 months. And yet it may be a great opportunity for an entrepreneur to start that dream business that they've been thinking about. So you take the classes, and then we're going to have our business plan competition that would give, if you win it, you win some seed money. It's a win-win situation. If you know of anybody who needs small business resources, please have them give us a call here at the Chamber, and we will send them in the right direction. Thanks, Dr. Price. Thank you, Jacob Wallace. Thank you, everyone, for attending, and we'll see you at the next event. Thanks.